Smile. Got all excited, didn't you? We started it now.
We just all need to.
Yeah, I know. Yeah.
You know what? She was so good.
It's always nice to hear.
And she was like, let's run it.
We're live streaming.
She was
Okay, thank you, Tony. With delay.
Smile, your mum might be watching. All right, if able. Seventh-rate appeal in the name of King on the application of AXO and First-Tier Tribunal.
Good morning, everyone. Well done for getting in. Yes, Ms. Webb.
My lords, my lady. So a couple of points of housekeeping arising from yesterday, then I'll proceed with the ground four submissions and include some short observations on the DSD case at the end of those, and then briefly revisit the issue of double recovery and whether it has to be on a like-for-like basis, which seems to have...
That would be very helpful.
So that's my plan, my lords, my lady. So in terms of what I've just headlined as housekeeping, you first of all wish to know some background to the introduction of bereavement damages under the Fatal Accidents Act.
Yes.
I've drafted a note. It's not agreed, but in the sense that those Mr. Hermer and Mr. Nichols haven't had the opportunity to read and give their blessing to it.
I'm sure they won't mind you showing it to us.
So I think I have it sets out, it pastes some material from Hansard and from a CICA document. So if I just hand those,
yes, if
that's all right.
Well, I hope it didn't mean that you were up all night.
No, I wasn't. You'll see the note isn't very, doesn't attempt to do anything very sophisticated other than say, here's what I've managed to find in the course of the evening.
It may well be that this is among what we have here, but I asked the judicial assistants just to check what the level of the bereavement award was in 2008 at the date of the scheme, and it was well, I think it changed, but I think at the date the scheme was introduced, it was £11,000.
Right.
Or 11,800. Sorry.
So, yes,
so it wasn't exactly the same as under the scheme, but it was there or thereabouts.
No. So yes, absolutely. Originally it was 3,500, I think, when it was first.
Yes, and it went on going up.
And then has gone on going up. So just by way of brief speaking points, the Fatal Accidents Act itself doesn't include a definition of bereavement, and there's no explanatory note. You'll see when you, if these pasted materials from Lord Helsham are of assistance in the debates, there's reference to a Law Commission recommendation in 1973 and a Pearson report on civil liability from 1978. I didn't find the Law Commission material online, so I haven't produced a kind of hyperlink, but the Pearson report I did find, so there is a hyperlink there. But what the comments from Lord Helsham are were that there were the Pearson report appeared to have a broader approach and termed the head of loss as loss of society, whereas the Law Commission recommendation had a narrower approach, and Lord Helsham labelled that as bereavement. And when I say narrow, I refer to a narrower class of individuals entitled to it, as compared to.
Well, that looks very helpful, and in the material about the CICA scheme, the CICA in fact draws attention to the fact that the sums are broadly the same.
Well, so I think, my lord, in terms of just on the issue of a point I made yesterday, the CICA scheme exists. It's its own beast, if you like. There is a wider class of individuals or qualifying relatives under the CICA scheme than under the Fatal Accidents Act for bereavement. So, for example, a natural parent of a child, if the child was an adult child, would be entitled to a CICA bereavement award under paragraph 39, but would not be entitled to a bereavement award under the Fatal Accidents Act should they have brought a civil claim. So that's one example. There are other examples as well, which I
Yeah. So your point is that the bereavement schemes, if we can call it that, the bereavement aspect in the scheme and the act is certainly not identical.
yes,
Because of a different class of different groups of potential beneficiaries.
yes,
And the sum isn't identical, although it's clearly in the same ballpark. And when the scheme was introduced, the fact that it's in the same ballpark is referred to. But your point is, nevertheless, the scheme is is a different scheme and not the same. So I'm repeating myself.
yes. Thank you. No, absolutely. So and it may be interesting, it may not be, that this difference of numbers of individuals entitled to it, narrow
Yes,
or
quite.
less narrow, was discussed and examined in the Pearson report versus Law Commission, but I haven't got into that. And it may or may not be relevant to note at this point that the Fatal Accidents Act, when I was looking at it last night, doesn't extend to Scotland, whereas of course the CICA scheme applies across the UK. I haven't researched how fatal accidents may or may not be compensated
Well, we
in
do know
Scotland,
that in
but there is
Scots law they are entitled to, I think, a Scotch common law, certainly. A spouse and possibly other family members are entitled to damages for loss of solatium, which is well, Lord Helton makes the point here, doesn't he? Actually, he doesn't actually use that term, but I think it's the same thing. Which may or may not be, it's obviously close to bereavement, but it may not be quite the same thing. Yeah, thank you.
So there we are, and just briefly on the CICA material, so that's over pasted on the third page. It's not really it's just grappling with, well, how do you represent it in money terms? So it doesn't really discuss what it's for, say for this phrase, how can you adequately cost a life? So it's not very I'm not sure how far that gets things, my lords, but that's all that's what was found. So it's a command paper presented to Parliament in 2005 in the context of a consultation. So again, background material.
Yes. But am I right? Sorry, the Pearson report isn't the same as the Law Commission recommendation of 1973. It would perhaps, I'm sorry, I rather skim read this, and the clever points I made about Scotland, I see in fact are already made in Lord Helton's speech in 1982. But have I trying to read it more slowly. The Pearson report, you were given the link, that's helpful. But that's not the same as the 1973 Law Commission report.
No, and
which we could obtain just by ordinary going to the library. And I don't rule out, depending how important we think it is, that we may do that. So be alive to that. Okay.
Thank you.
Thank you.
So
Can I ask you, Ms.
yes,
Webb,
of
kindly
course.
to let the audience have a version electronically?
Of course.
Put it on the list on a non-urgent basis. That'd be very helpful.
So
Thank you for doing that work.
Thank you. The second, just brief housekeeping, is that an authority indicated called Grant was sent in by the appellant's legal team yesterday.
Yes.
Concerning the issue of this loss under the common law, under Fatal Accident Act claims. What does this loss of parental services award represent? And I agree that is the correct authority.
Do we have a copy? Yes.
Should be behind a new tab 34.
Oh, yes.
Okay, thank you.
I looked at it briefly on the screen, and because there was rather a lot going on this morning, I didn't read it properly. Which is the relevant paragraph? I appreciate it's not your authority, but as you're on your feet, which do you understand to be the relevant paragraph?
I don't have the paragraphs at my fingertips, so I understand its authority for the.
Well, let's
Yes.
ask Mr. Hammer.
Thank
Mr. Hammer, which of the passages you were going to refer us to?
94 to 109. And it's the principle that those type of loss of services are pecuniary loss, not non-pecuniary loss.
Yes, I see. Well, there's two ways of dealing with this. One would be probably the better way to let you deal with this in your reply, and then allow Ms. Webb to come back on that particular point when she's heard what you make of it. That's probably better, isn't it, Ms. Webb, unless you've worked it out already, or maybe you've said all you need to say.
No, well, I'm grateful to have the opportunity to come back and further reply if I
Well,
need to.
why not do that?
Thank you.
Okay, thank you.
So then, moving then to my submissions on ground 4, which is obviously the Human Rights Act damages point, and I was just finishing off my first heading, which is the general approach to awards for non-pecuniary damage in Human Rights Act claims generally. So can I've taken you to Greenfield, can I take you briefly to the practice direction? It's at tab 32. Paragraphs I'd like to ask you to have a look at, paragraph 2 and paragraph 10.
Sorry, I've lost my place. Where I am meant to be in the practice direction, am I?
Yes, please. Tab 32, it's page
Got it.
134.
Thank you. And within that paragraph,
So paragraph 2, the first sentence that emphasises the compensation in general under Article 41 is to compensate for actual harmful consequences of a violation.
what am I looking at? I'm looking at the Strasbourg Court's practice direction.
Yes, so
Is that, I mean, where does that stand as authority? Shouldn't we be looking at the case if there's a tension between them? There is or there isn't.
I suppose in preparing the bundle, there was a number of authorities all attempting to summarise the principles of the European Court. So I considered this was a relevant material to have before you.
But it must have some formal status, whether, and indeed you see from the footnote, that it's issued in accordance with Rule 32 of the rules of the Strasbourg Court, and amended on the, yes. Well, I think we would like to see, if we may, Rule 32, so we can understand. Rule 32 may specify what its status is, but it may not.
Just predicting the point, I think the point we're going to make is that the purpose of an award is to compensate the applicant for the actual harmful consequences of a violation, which I think you're going to say leads you to look at what actually happened as a result of the violations. And we were taken yesterday to quite a lot of case law that might not be seen as completely supportive of that proposition, at least not in the fair way it's put here. So that leaves us in a slightly difficult position of knowing which is the authoritative, which you say is the authoritative source.
So I think paragraph 10 may assist. I will attempt to answer that as I go along, my lady. Just to flag, I think it's in Al Saran that cites the practice direction as well. So
Yes.
I think that the UK courts have found this.
Oh no, and
material
nobody I think is suggesting it isn't helpful.
Yes.
It's just a question if, which may not turn out to be the case in the end, but if
Yes.
there is effectively a disagreement between what the practice direction says is the result of the case is and what some of the cases say as the result of the cases, which is authoritative, if either. And on that, it would just be helpful to know the formal position, which means looking at Rule 32.
Yes,
And while
thank
we're
you.
making work for your junior, unless it's completely can't be found, I think it would be useful to see what the version of the practice direction that was available in 2007 said. It may have been very similar, it may have been quite different. That would have been the version that Miss Justice Leggett had in front of him in Al Saran.
I see, yes.
But okay, now para 10 you wanted us to go to.
I've just been handed Rule 32, the practice direction. Would you like me to read it out? Or would you?
Well, why not? Yes, thank you.
Rule 32 says the president of the court may issue practice directions, notably in relation to such matters as appearance at hearings and the filing of pleadings and other documents.
That's all.
So that's all. That's what it says.
Well,
I suppose, my lord, what I would say is to the extent UK judgments have said, here we are summarising what the approach of the European Court is, referring to the practice direction. If there is any kind of paraphrasing or ambiguity or difference, you may prefer this. But my lady, my point isn't going to be quite so simplistic as to say, therefore, only in respect of the death in an Article 2 claim, for example.
I'll tell you what, let me take us all the passages you want us to take us to, make your submission.
Yes.
And then if we want to still think it's important to follow up all the stuff about it, we'll do so.
Thank you.
Okay, so para 10 is where you want us to go next.
Yes, well, I just second the last, you may feel it relevant, the second, but the last sentence of paragraph 2 of the practice direction. The court has therefore considered it inappropriate to accept claims for damages with labels such as punitive, aggravated or exemplary, nor does the court make symbolic awards. And then turning over the page, paragraph 10.
That seems to equate, the term moral harm seems to be a paraphrase of what was referred to in the 2 lines further up, non-material harm such as mental or physical suffering.
Yes.
But if you read 10 to 13, it's a very broad. Because 13, for example, you have regard to the nature and gravity of the violation found, the duration of effects, several violations. So it's if you're trying to equate it to a common law, it's a broad discretion that takes into account all the circumstances of the the context, as they say, in which the breach, the context, the impact. So it's broad.
So it is broad, but
if this is the analysis that's undertaken,
but it's clear. I hope I'll answer or address your point. Moral harm, it's specific harm that needs to be identified. So it can either be evidence, but it can often be assumed or inferred from the circumstances of the case or the conduct, and you may consider that's the appropriate way to fit in these broader considerations covered in paragraphs 12 and 13. So what is to be inferred or assumed? has been the actual impact on an applicant.
I think with respect that 13 is much broader than that, and it's not looking at the actual impact, or it's not confined to, because it's talking about factors considered by the court. And were you coming on to 13? Because you said read 10, and that's why I was thinking of one is if you read the whole of that section, it seems on a first reading anyway, because I haven't read it before, that it's a broad, which is the whole, in a sense, underlying the whole scheme. It's a very broad assessment that isn't categorized, quantified. It's whatever the court considers is a just amount, having regard to all of the circumstances the court considers relevant.
Well, my submission would be that taking paragraph 2 and 10, the approach that there needs to be an identification of the harm caused by the breach. The analysis I've just set out, the context, the nature, the violation of the nature, the gravity of the violation, all go to inform the court's assessment of what the harm is, rather than there being some sort of punitive punitive type approach. This was a really bad violation, therefore the amount must be X. The approach is rather this was this sort of situation, gravity of violation, nature of violation, therefore the understanding of the court is that specific harm has been caused to a claimant to a particular degree, and therefore they assess the
So really what you're
compensation
saying,
on
I
that.
think, is that if you look at the factors referred to in 13, nature, gravity, duration, effects, those are relevant factors because they are likely, if it's of a long duration or if it's particularly serious, it is more likely to have done a greater degree of harm.
Yes, depending.
Not that those are separate factors in themselves, because if they were separate factors in themselves, you'd slip over into really making it symbolic or punitive.
Yes.
I mean, funnily enough, we all like our own cases best, but I did a judgment in the EAT on the nature of aggravated damages in common law, really making a rather similar distinction, saying that aggravated, although you can find some very broad statements about aggravated damages where something's particularly outrageous or whatever, the outrageousness was relevant only because an outrageous attack on your identity, and it was a discrimination case, is more likely to hurt you more than a less outrageous one, not because its outrageousness was a factor in its own right. And that sounds like the same sort of distinction.
Yes.
I'm not suggesting you look at it, but it's a case called Shaw and Metropolitan Police, I think. But I'm not putting words into your mouth. That's the sort of point you're making
That
about
is.
para 13.
Yes.
Yes, I see that.
And just before I turn on, so that's all I had to say about the practice direction. Before turning on to Article 2 specific damages, I'll just pick up, if I may, on a couple of other points on moral damages, because it seems to slot in here. My Lord, just in terms of homework on that topic, we haven't found anything in the domestic context. You have it in the case of Sternum. I'll just flag it's paragraph 32 on page 607, describes.
Sorry, just give me a moment.
Yes, of course.
Sternum, did you say?
Yes,
Which tab?
it's at tab 12.
Moment.
Sorry, no, it's not 15. Page 607.
Sorry, which paragraph?
32.
Thank you.
Sorry, and which page?
Yes, of course, 607.
It's 07. Ah, takes us a little bit further. So perhaps, depending how diligent anyone feels, some French legal dictionary might give you the answers to what moral damage means.
Perhaps. So, my lord, I don't have any submissions on that paragraph, but just wish to flag that.
No, that
resource
is
to you.
helpful.
And then, may I just briefly mention Al-Saran? I don't know if we need to turn it up. There was a paragraph 914.
Well, let's turn it up just to
It's
remind us.
887 tab 22.
Yes.
And in, so 914, and then I'll just, there was a point you've queried about 915. So in terms of 914, I just wish to highlight, there's a discussion here where,
We're on page 914, are we?
I'm so sorry, page 887, paragraph 914. So the first point I wish to make is flag the last sentence of the first paragraph. So, well, it's two penultimate sentence as well. This may require account to be taken of moral injury, as stated by the Grand Chamber in Varnava versus Turkey, in some situations, and then there's a quote there. So, just a short submission. Concept of moral injury here is indicated as in this authority indicated as applying in some situations, so it's not automatic. You have a breach, therefore there will by of necessity have been a moral injury, or a moral injury requiring monetary compensation. And my lords, if my lady, just the second point in this context is these cases cited, Al-Jeddah, Al-Saran, and also Varnava in Turkey, all concern violations committed by way of positive actions by state actors. So Al-Jeddah, arbitrary detention for 3-year period. Al-Saran, alleged torture, arbitrary detention by state forces. Varnava in Turkey, arguable claim of detention and disappearance by Turkish military forces. So not the sort of Osman type scenario where the cases concerning state emissions, they're not the same sort of case. So one can't automatically say, this, I don't think this.
No, but the fact is, we know in this case, Article 2 non-pecuniary damages were agreed.
Yes.
Even though it's an Osman type case. And really what we're looking at this is not some general question about is it appropriate to be awarded in this or that case, but what it means, what it's for when it is awarded.
Yes.
So thank you for pointing that out, it's always accurate. It doesn't really advance the argument, is it?
Well, I suppose there isn't, I suppose my point here is that there's no authority to support an assertion that necessarily an element of Article 2 damages in a claim brought by a bereaved relative amount to this sort of something further element, moral injury element required in certain cases. I don't know if
So you're saying you can't assume that if you're
Yes.
faced with a convention award under
Yes.
Article 2 in an Osmond type case, you just can't assume that it contains a moral injury element.
yes. In the sense that it's been contended they're sort of severable or separate from the death or bereavement.
Can I just ask you in that context,
Yes.
in the middle of the second quote, there's a sentence that starts, its guiding principle is equity, which above all involves flexibility, etc. And then it says, say, have regard to what's just fair in all the circumstances, including not only the position of the applicant, but the overall context in which the breach occurred. How does that phrase, or how does that, the latter part of that sentence, fit with your submissions on the, in respect to the practice direction, that there needs to be a sort of connection? Because is a distinction between being drawn, or what is the distinction being drawn, do you say, between the position of the applicant and the overall context?
Well, my lord, I think my answer to that is the position of the applicant is both those points, position of the applicant and overall context, inform the court's assessment of what damage can be inferred to have been caused in to that applicant. So I don't read position of the applicant to mean not only the harm to the applicant.
Thank you.
So then, can I turn to 3 cases where Article 2 damages were awarded in claims brought by bereaved relatives?
Just a small point before we
Yes,
leave
of
this,
course.
it just reminded me. I think, I forget whether it was you or that's probably Mr. Hermer. I just asked if we could have the passages being referred to by Mr. Justice Negros at the end of para 915,
Yes.
where he talks about his previous discussion of aggravated damages. That someone's doing that, I think.
I've got that, and apology. Thank you for reminding me. Paragraph 874. It's not in the bundle because we were trying to keep.
No, I'm
keep
not
the
criticising you,
notes
but I
down.
mean, I wouldn't mind seeing it now. I
Yes,
don't mean
paragraph
literally now.
800. Well, so
Have you-
what we understand it to be is paragraph 874, but Mr. Hermer may have another reference. I haven't discussed that point with him.
No, I just physically wanted the bit of paper.
Oh, I see. So we'll.
No.
Sorry.
Well, don't worry. I can. Now I know which paragraph it is. I can find it for myself. But if
Would you like me to read it out? Your Hermer?
not really. It's just we're going to have to do a number on these paragraphs. It's important to
Yes, of course.
track down all the references. But you agreed it's para 874, are you, both of you?
And there are actually a few paragraphs that follow. We were going to put that all in the note. That we
Oh, I
were
see.
going to provide
Okay.
the court
Well,
with
that would be
tomorrow.
very helpful. Good. Okay.
Thank
Yeah,
you.
sorry. And you were now going to take us to 2 or 3 more cases, you said?
Yes, please. Edward, Savage and Rabone. So starting with the case of Edward, so that being in the second bundle. So it's tab 27. And I'll take you to a few specific paragraphs. I'll just briefly outline the case. Just headline points of the propositions I extract from these cases. Firstly, these are examples of non-pecuniary damages being awarded in respect of the loss or bereavement, and not for breach in the abstract. And secondly,
Hang on 1 second, sorry. Sorry, not what in the abstract?
not for the breach in the abstract.
Thank you.
Secondly, the right to bring an Article 2 claim is capable of being extinguished for a relative in an indirect victim claim where a Fatal Accident Act bereavement award has been received. Or conversely, the relative has standing because such an award is not available to them. So,
Get that last bit. I'm very sorry.
so it's or conversely, the relative has been found to have standing because such an award or remedy is not available to them.
So a right to an Article 2 bereavement claim can be extinguished if a statutory bereavement payment has been made. That was your first point. And then the second one was?
Yes,
or conversely, you said.
Yes, so I suppose it's the same point. The availability of a Fatal Accidents Act bereavement award is relevant to whether or not an applicant has standing for an Article 2.
As a victim, as standing as an
yes,
indirect victim.
Exactly. And my
okay,
submission,
thank you.
yes, thank you. So in terms of Edwards, just briefly an outline before I take you to a few paragraphs. It's the applicant's son died after being attacked by a dangerous mentally ill fellow prisoner who had been placed in the same cell. So the parents of the deceased brought a claim that the state had failed to protect their son under the operation obligations under Article 2, and so was responsible for the death. And there was also complaints in terms of breach of the investigative obligations under Article 2. And there were breaches of Article 2 and 13 were found. In terms of unavailability of the bereavement award under the Fatal Accidents Act for these applicants, that's covered at paragraph 39, which is page 1099, I think.
Yes, I see.
And then having found a violation of Article 2, there's a discussion of Article 13 and then damage, and that's at pages 1116 and over the page 1117. And there are a few paragraphs to pick out.
Can we read the sideline passages?
Yes, so hang on, 97, 99, I was 101, 104, and I would say 106 with a
I see, so all,
thank you.
and 106, okay.
Yes, please.
Yeah. Yes, thank you.
And the breach here looks like it was twofold. It was a substantive failure to protect, but it was also a failure of the investigative breach. They didn't hold an inquest or inadequate.
Yes, yes, and there was a claim also in respect of the pain and suffering of the individual son as separate from the parents. Obviously, in AXO's case, there was a separate award to the estate of her mother. So there are some differences.
Is that right, by the way? I'm sure it is right, but I hadn't spotted that.
So,
You know, 106. In addition to the pain and suffering which he must have experienced, the parents must have suffered distress from, as my lady says, those two different causes of action. And that's 20,000. I see. And then for this, where's the bit where he gets an award? The estate gets an award for his suffering immediately prior.
So sorry, so I've probably been unclear. So the award was solely to the applicant parents, but it represented suffering of their son and then their own suffering.
Yes, I mean that wouldn't work as an English context, would it? I mean, in English context, we'd split this. The suffering he had would be in a claim for his estate, and the suffering they had, if they had a cause of action for it in domestic law, would be a claim to be brought by him. And I imagine even if by the parents themselves, yes. And I imagine even if they were making a claim under the Human Rights Act, which of course this is Strasbourg, probably we'd insist on them being separate applicants and recovering separate awards.
Yes,
but that's not how it was done here.
No, not how it's done here. But it was in the case of AXOs, there were separate Human Rights Act damages awards in the settlement. So it just in general terms here, paragraph 97 focused on damage flowing from the breach. Paragraph 99.
Hang on 1 second, sorry.
So sorry. It maybe you have these points, or you're not assisted by me going through them in granular level, but just to draw out paragraph 97.
Emphasis on damage flowing from the breach. Yep.
Yeah, 99. So it talks about in court recalls in general actions in the domestic courts for damages may provide an effective remedy in cases of alleged unlawfulness or negligence by public authorities, and then there's a discussion about the Fatal Accidents Act claim could have furnished a fact-finding forum.
That could have dealt with the article, with the investigative aspect, I think is what they're saying, isn't it?
But
they chose not to for perfectly good reasons, but that they're under the FAA, under the Fatal Accidents Act, I think the point the court's making is that they could never have got damages because they were knocked out of the bereavement award.
Yes.
But so, the implication of that point, so it's not actually the point being made in para 99, but the implication of is that the bereavement award under the Fatal Accidents Act might have been sufficient just satisfaction for the loss of the child.
Yes.
But as I say, that's implicit rather than explicit. It's not quite what they're saying here.
I agree.
Okay.
And it's exactly, it's implicit, not explicit. I'll invite you to find it's a bit more explicit in Rabone, and I'll take to those paragraphs. And then paragraph 101, again, the bit about availability of domestic remedy, so that you may find assists as well. It has that phrase, the possibility of obtaining an enforceable award of compensation for the damage suffered thereby. And then a description of the damage awarded at 10416. So, shall I turn to Savage then?
Which tab.
It's tab 12, starts at page 389. I don't mean to take you through the case in detail, just briefly. This is this is the first instance decision coming after the House of Lords considered the applicability of the Article 2 operational obligation in relation to mental patients detained for mental health issues. So it's if you like, a first instance consideration then, but following that House of Lords consideration. And at pages 408, 409, paragraphs 94 to 97, I invite you to find an example of how Article 2 damages are in effect compensating for loss of the family member.
Yes. Presidential guidance doesn't like the word symbolic, but to be fair, I don't think Mr. Justice Mackay is using it in the bad sense. I think he's simply making the point that the point we often get, that money can never compensate you for the loss of a family member. So it's symbolic in that sense, but he's not doing it just as a symbol. He's doing it because she has suffered a compensatable loss.
Yes.
Yeah.
So that's the only point I wish to take from Savage. And over the page is Rabone at tab 13. I'll briefly outline the facts and then ask you to look at particular paragraphs if I may. So again, this was similar to Savage, and it's a psychiatric patient. This was someone who was voluntarily detained, so there was an issue as to what extent the Osmond duty applied. It was an adult psychiatric patient, and having been allowed to leave hospital, committed suicide, and the parents brought a claim against the NHS Trust for breach of Article 2 and on behalf of the deceased estate under the Law Reform Act. So there was no claim under the Fatal Accidents Act. And the Article 2 claim was advanced or developed purely on the basis of the positive obligation to protect life, the Osmond type duty. And one issue at the Supreme Court was whether the settlement of the negligence claim brought on behalf of the estate under the 1934 Act meant the parents had lost their victim status for their Article 2 claim. The Supreme Court said no and went on to award damages. So if I take you through Lord Dyson's, just highlight some relevant paragraphs if I may. The first one is paragraph 49 at 431.
Mm-hmm. Yes.
So, my lords, yes, there are two conditions when someone may cease to be a victim. Firstly, adequate redress. Secondly, acknowledgement of breach. And the majority of the discussion, the judgment focuses on the first one because of the fact of the settlement. And the conclusion on that is paragraph 57. So if I could ask you to have a look at paragraph 57.
Yeah.
So, my lord, yes, that bit towards the end, the head of loss embraced by the settlement broadly covers the same ground as the loss which is the subject of the Article 2 claim, etc. So that's the relevant bit, and then it's applied to 58, and of course there was a finding that by settling the claim on behalf of the estate, they hadn't renounced their Article 2 claim on behalf of himself and Mrs. Rabone for damages for non-pecuniary loss for their bereavement, and a discussion about the non-availability of a bereavement award under the Fatal Accidents Act. Same point at paragraph 59. Paragraph 72, briefly, it may not be, you find this of particular
72.
relevance, but it's, I'm sorry?
72.
72, yes, that's about the second condition to satisfy the acknowledgement of a breach. So by making an admission of liability in the context of a domestic claim, that can be taken in substance to be an acknowledgement of a breach of a convention right.
Yeah.
That's what I understand that to say. So this is all going to how, while domestic claims and convention claims actually aren't necessarily so very different. Convention may step in where domestic law doesn't allow for something, but just because something can be conceived as a convention right or convention issue doesn't mean that it is incapable of being compensated or dealt with in a domestic sense. And then Lady Hale at 92. Page 442. Just in her introduction, and mostly I think the discussion considers standing as indirect victims, but the first sentence, we're here because the ordinary law of tort does not recognise or compensate the anguish suffered by parents who are deprived of the life of their adult child.
Mm-hmm.
And final reference in this case, paragraph 124, Lord Mance at page 452. And it's halfway through that paragraph. I agree that Mr. and Mrs. Rabone did not in this case lose their victim status by Mr. Rabone's acceptance of a settlement figure which was on behalf of Marion's estate alone and which did not cover their bereavement. So that.
Yes, thank you.
Thank you. A quick note on Shanahan, which was the new case provided. I think it's at tab 33. I'm losing track of 32. Bear with me. I'm not sure. I think my lords, my lady had the point that I would want to make yesterday. This case concerns violation of the Article 2 investigative obligation, so I'm not sure how far it gets the arguments, and that was looking at paragraph 144. Have I given you the correct tab yet? Tab 33 in it's my notes.
Yes, sorry, 144 you were saying?
Yes, so I
Yes.
think,
Yep.
it's just an example of the court identifying harm flowing from a breach, but in this case the breach was a failure to carry out prompt and effective investigation, which was found thereby must have suffered feelings of frustration, distress and anxiety. It's a different sort of Article 2 case. You may find it interesting or of relevance. Paragraph 27 characterises the sum received from the CICA scheme being as in respect of the death of her son. That's just straightforward common sense.
Sorry, where are we? 27?
So sorry, paragraph 27. I don't have pagination for this one, so
Internal page 6.
internal page 6, yes.
Okay.
So,
But here, sorry,
yes, of
just
course.
rewind a little bit. But Shanahan is an example. So you've got the court,
Mhm.
Strasbourg court, accepting that there's been a payment in respect of the death of an individual.
Mhm.
Accepting there's been a breach of Article 2, albeit a different sort of breach,
Mhm.
but going on to make an award that is distinct from the CICA award
Mhm.
to reflect that's the convention element of breaches.
So if we're looking at paragraph 144 in kind of English law terms or tort law terms, the injury is different. The injury is feelings of frustration, distress and anxiety flowing from failure to carry out a prompt and effective investigation, and that has parallels with the DSD case. So it's not, it's identified and also it goes on to differentiate in paragraph 144 what the CICA was doing, damage flowing from a criminal act, not lack of procedural efficacy in the investigation.
Very different cause of action in English language.
Yes. Different you could imagine, and we'll come to it in DSD, that's probably, and I'll come to that shortly, where one of the applicants, we've got different sorts of damage. And an extent of overlap and also completely discrete harm. So perhaps I'll speak more clearly when we're looking at DSD. So let me just, if Matt,
No overlap cases.
No overlap.
That's the one.
Yes,
No overlap.
no
cases,
overlap.
That's right.
Thank you. So before I turn to DSD, because that's not an Article 2 case, perhaps it makes sense for me to address you on the arguments in respect of AXO, and how the way the appeal is being put has developed. So as I understand it, the argument is there is an element of the Article 2 damages which may be in respect of grief or bereavement, but that's not the whole story, and some of it is in respect of something else. So, and whether classed as moral harm or otherwise. So it seems there's a sort of argument that there's a severable element within the Article 2 damages. So if I take it in stages, the CICA's primary position would be that the whole amount of the Article 2 damages can fairly be analysed as being in respect of the death.
Okay, hang on 1 second.
And for the reason that you can't assume there's within that an element of pecuniary compensation for moral harm.
That's
separate
assuming
from
against yourself that moral harm has the wider meaning.
Yes.
Okay, hang on
Well,
1 second.
well, there is this concept, quite nebulous concept. It's not automatic. That there is no authority. That yes, that you can't assume that there's some separate element labelled moral harm or otherwise. So that would be my first submission. And
Does that get now or later? Can you just clarify? I went over my notes yesterday, and
Yes.
I'm sure it's my failure. I haven't got it quite clear where we are on the overlap point or the double recovery point.
Mhm.
Part of this first primary case, do you accept that CICA can only recoup to the extent that there would be double recovery, such that it is your argument that there would be double recovery because you can't assume there's a moral harm component? Or is it a different argument that says the language that you're looking at is whether the payment has been made in respect of the same injury, and you don't need to worry about whether that's confined to double recovery or not?
so I'll come to address in terms of double recovery. I've prepared some short submissions in terms of the like for like point. So insofar as there's a suggestion that only a certain element of the CICA award, i.e. the paragraph 39 award, the level of that money, 5,500, can be recouped against the Article 2 damages award. And so a heads of loss type, like for like, double recovery. My lady, is that, because I think that's one question. The other question is the otherwise the straightforward analysis is this damage, is this compensation or damage award in respect of the death? If it's not in respect of the death, then how do you deal with that? But if it is in respect of the death, then the CICA is entitled to view it as a payment made in respect of the same injury, and regardless of how the heads of loss line up, it's recoupable. Does that?
Honestly, not really.
Okay.
But I think what would be better if I
Yes.
think I shouldn't have interrupted you. Let's get to the end, and then we might need to do more.
Yes. Thank you.
Can I thought I did understand you, but I agree it wasn't quite clear. I think what you're saying, this primary submission, you are saying that double recovery, in the sense in which Mr. Hermer was using it, like for like, is not a requirement for the operation of the exclusion. At this stage, it's enough that the sum in question is in respect of the death, even if you can't satisfy a like for like test. Is that?
Yes.
Yes.
So
That's what I understood you to be saying, but no doubt it'll be reinforced when you come to the end of your submissions.
yes. Let's see how I get on, and if I'm being completely unclear, no doubt you'll let me know. So just in terms of that first position, you can't assume an element for moral harm. 3 points to make. case law, moral harm may be applicable, but it's not automatic. Second point, domestic.
Sorry,
sorry, I'm going too
3 points.
fast.
Moral harm may not be applicable, but it's not automatic. Not sure I
Sorry,
understand what that
that
means.
wasn't very clear.
Maybe there, but it's not necessarily there.
Yes, thank you.
Sorry, now it's
So
me who
sorry.
still doesn't understand. Just give me
So-
the proposition one more time and I'll
So
write it
it's the
down.
proposition that I was trying to draw from Al Saran at paragraph 914, sometimes, and it depends. So,
So, just give me a sentence. Sometimes what?
bear with me, I will rather
Yep,
than
sorry, don't
paraphrase
take your time.
horribly. No, it's my fault. So, in some situations, the impact of the violation may be regarded as being of a nature and degree as to have
Sorry,
impacted. So sorry,
what's your proposition?
my
In some
proposition-
situations,
In some cases, there may be an element of what's termed moral injury.
okay,
Um,
but not all.
but yes,
Okay, thank you. You said 3 propositions, that
yes.
was
The
the first.
second is given, as we've seen in Rabone, for example, domestic remedies can be capable of providing adequate redress. By way of a bereavement award, which doesn't have an explicit element of which
Sorry, you're
is
dropping your
expressed.
voice.
So sorry, which is expressed to be in respect of the bereavement, i.e., in respect of the death. Therefore, again, the starting point for an Article 2 damages claim award can be viewed as being in respect of the death or the bereavement. That's a reasonable starting point.
You're saying the starting point should be that bereavement is a satisfactory
Well,
remedy.
so I suppose the third point, it's reasonable starting point for CICA unless there is some sort of separate harm, separate sum identified, which wasn't the case in this case.
I don't quite understand the concept of a reasonable starting point. I mean, this is a question of law, isn't it, in each case, whether or not what's the para in the skeleton in the scheme with which we're concerned?
49, I think. So.
Whether para 49 applies.
Oh, of the scheme, yes.
Yes. You're saying it's a reasonable starting point for
Well, okay.
surely it's a binary question. Is it in respect to the death or isn't it? And I'm just trying to tease out what you mean by a reasonable starting point, as if it was some sort of investigation or.
So CICA will deal with cases on a case-by-case basis.
But in principle, they'll just
Yeah.
look
Yeah.
at the award received in a 49 case subsequent to their own payment and say, this award they just received, is this in respect of the death? And on your primary submission, that it either is or it isn't.
Maybe I've overstated things. So I think there needs to be an analysis on a case-by-case basis, and the cases I've taken you to, such as Rabone, such as Edwards, you can these are examples where damages are expressed to be in respect of the loss or the bereavement and not anything more. If I'm secondary position,
Yeah.
if you're not with me on that primary position, if that's wrong, there's an element of moral harm or some other element in the damages wrapped up either on the facts on a particular case or as a matter of law. You may still be with me that given the requirement for a causal link between a Article 2 breach and a death, albeit less than the balance of probabilities death, balance of probabilities test, for a finding of liability, you may still feel that the damages, all of the damages can said to be in respect of the death.
Sorry, I didn't get that. But what is the secondary submission? I
Even
got as far as if an element of moral damage, but I couldn't quite see where it was
no, of
going.
course.
Can you just leave out all the qualifiers? What's the key submission?
Key submission is even if there's an element of moral harm
Yeah.
wrapped up in the sum, the payment,
Yeah.
you may still be satisfied that the whole of the sum can nevertheless be conceptualised as in respect of the death.
How's that different from your first submission?
Because the first submission was attempting to
I see. No, I've got it
conceptualise
there.
the
I've got
idea
it. No,
that
I've
it
got
was-
it. You're
yes.
saying you can't assume there is an element of moral
Yes.
harm. Yep. Okay. No, thank you. That's helpful.
So,
Yep.
third position, if I'm wrong about that, so there's a kind of suggestion or concept that CICA can recoup some of the Article 2 damages that are in respect of the consequences, so bereavement or loss, but not in respect of another element, whether defined as moral. Let's just stick with the phrase moral harm for the fact of the breach. I'd like to invite you to consider that it is artificial and unworkable for CICA to attempt to analyse how these Article 2 damages are to be broken down into their constituent elements. So 3 points, I think. Firstly, it's not done in the case law. Secondly, how would it work in practice? My lords, my lady, it was suggested yesterday the burden would be on the CICA, but realistically that information would have to come from the applicant. So would CICA ask for a breakdown? How could that as a matter of reality and practice be done? And thirdly, there was no breakdown in the AXO case.
Sorry, that was thirdly.
Thirdly, there was no kind of breakdown in the AXO case. It was a lump sum.
So the consequence of that submission is you can't do it. Who does that favour?
Well, that's yes. So the appellant's response, no doubt, would be if that's not possible, then don't touch it at all.
Yes.
And the CICA would respond, well, disagree. Human Rights Act damages need to be ring fenced in such a way they're a reflection of an international system providing a remedy where domestic law doesn't. My lords, it must be the case that the key loss or harm is the death and the
Sorry, can you
bereavement.
speak up? I mean,
So sorry, it's my fault. It must be the case that the key element of those Article 2 damages are the loss and the bereavement. So it'd be wrong to say, don't touch it at all.
But you do agree, because I think this is part, that it's non-pecuniary damage.
The Article 2 damages?
Yes.
Well, probably. I think it's yes, I suppose it must be. Again, it's a convention scheme, it's not a tort claim, so I don't know how helpful it is to use these labels, but
I'm
in
just
the
looking
exam-
at paragraph 11 of the practice direction
Yes.
that says it is in the nature of non-pecuniary damage.
yes,
So
yes, I'm grateful, yes, I agree. It's non-pecuniary.
what the moral harm is in the nature of non-pecuniary damage.
Well,
I mean, I don't think my lord was putting to you that you can get pecuniary damage under Article 2,
yes,
but moral harm, which is what we're talking about, is non-pecuniary. Is that right? I'm not quite sure what proposition you were agreeing to.
no, I think, yes, I think we're talking about, yes, all the cases we've been looking at are non-pecuniary harm.
The whole lot. It's
For the
it's
whole lot. Yes.
I've called it dollop. I'm sure there's a better word for it, but you know what I mean. The figure that the
Yes.
Strasbourg Court arrives at
Yes.
is treated as non-pecuniary, isn't
Yes.
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 I perhaps confuse matters. It's the whole. I agree with my lady. It's the whole amount. One element in which may or may not be moral harm, but that's non-pecuniary too.
Yes.
that
Thank
was
you. That.
the
If we,
proposition.
sorry,
That was the proposition.
sorry. Well, it's my fault. I was just.
I'm
Getting
clearly being
confused.
slow this morning. No, it's all non-pecuniary harm.
Yeah.
So the £10,000 that AXO received was non-pecuniary, was in respect of non-pecuniary harm. Obviously, she received compensation for that in money terms, but yes, non-pecuniary harm.
Below, you were, by claiming the full 15,000 that you had paid, you were in fact claiming 5,000 out of the 22,500. Is that right? That, which was pecuniary, but that we're not concerned with that anymore. Am I muddling myself?
The Article 3 point was
No,
yes,
not
is-
Article
is-
3.
Oh, so the £15,000 was made up of £10,000. If we're talking about the AXO's
Yes,
human rights act damages, it's £10,000 under Article 2, 5,000 under Article 3.
Oh,
but
I
all-
see. Sorry, I was confusing myself. Ignore the last minute.
Okay, so shall where I propose to go now, those were my key points in terms of Article 2. I was going to address you on DSD, and I was also going to address you in terms of like-for-like recovery. And I wasn't planning to address you further on grounds 5 or 6, unless you would like, in terms of which is the effective remedy point. I think I said all I had to say
You'd said
yesterday.
yesterday that they really folled on from, if you were right on
Yes.
the other points.
So therefore, shall I turn then to DSD?
Yeah.
I really, I can take you through the case in detail, but the key paragraph is 65. Before I ask you to turn it up, shall I just draw out a few points in general terms, or would you like to refresh your memory as to what the case was about? It's the War Boys.
Yes, no, I remember what it was about. I mean, you do what you think is best.
Okay, so in terms of my general points, firstly, the context of this decision is the defendant police force seeking to avoid paying damages for a finding of liability against it, arguing that the War Boys settlement and the CICB payments were sufficient remedy for the claimants. and clearly that's a self-serving argument. In my submission, the fact of the CICB payment should have been completely irrelevant to any consideration of just satisfaction, given taking it into account gives the defendant at fault a windfall in not having to pay damages which they may otherwise be liable to pay. The second point is that if one reads the case, and if there's a lot of focus on the nature of the payments arising out of the claim made against war boys and how they do or don't fit in with the Human Rights Act just satisfaction provisions, but there's no real analysis of the logic of that applying to the CICA award. So what I mean by that is section 8.3a, which is in the bundle of the Human Rights Act, talks about how courts have to take certain things into account when considering just satisfaction. And 3a says, well, it says no award of damages is to be made unless taking account of all the circumstances of the case, including any other relief or remedy granted or order made in relation to the act in question by that or any other court. So that subsection deals with court, goes on to consider courts. So the only way a CICA award fits in is if it fits into the taking account of all the circumstances of the case. It's not another court award. It's only a kind of fits in under that general circumstances. And to the extent, and there's no recognition in the judgment at all of the CICA award of those circumstances, including the recoupability of CICA awards.
Sorry, could you say that again?
So there's no recognition in the judgment at all that CICA awards are liable to recoupment.
Yes.
That is right. He does rather assume, doesn't he, that what he's doing is that's rather,
Yes.
Mr. Justice Green, that he's carving out a space for the CICA award. I mean, he's definitely trying to tread round it. He's aware of the CICA, isn't he, in what he does? And he's saying, I'm compensating the bit that wouldn't be CICA. That's the whole thesis, isn't it?
Yes, well, it's taken into account. It's not really drilled down exactly how or why, and we can, but I think the point is, what's the rationale to take it into account? And we can leave aside the issue of whether or not CICA can recoup against Human Rights Act damages or not. I mean, but even just straightforwardly, there's been a settlement against war boys, the criminal perpetrator, and there's no discussion or recognition that the CICA payment in respect of the rape or rape. So I mean, again, there's only potential overlap really with one of the claimant's NBV. So a criminal injury rape, CICA award received in respect of that rape. Surely it's completely relevant to note that that award is recoupable against the war boy settlement. Now, there may be an issue about the war boys not being good for the money, whatever, but it's just not even touched on.
At any level, what I mean at any level, first instance in the Court of Appeal or in the Supreme Court, that's not addressed at all.
No.
And that's why yesterday I noticed that the award was specifically approved, or the judge's award was specifically approved both in the Court of Appeal and in the Supreme Court without comment.
Without comment, yes. And I was going to, you have the point, the issues on appeal was liability and not quantum, both Court of Appeal and Supreme Court.
Yes.
So the point was just never, I mean, surprising in a way to go through that number of levels of court and that number of lawyers without it being touched on.
Well, yes, and I mean certainly it wasn't in the defendants. No one's really thought about it. I think.
That's I suppose I just question that, because wasn't it the working hypothesis, wasn't the assumption that was being made that if there was overlap, because Mr. Justice Green spends a lot of time looking at the cases on overlap, and he talks, if there was overlap with he's awarding things that he does not consider to overlap. Now, whether the CICA award would separately be offset against the award for damages obtained from war boys, that wasn't before him, and he didn't need to worry about that at all. But he, as I understand it, was looking in some detail at what was the requirement outside what those victims would get, either from CICA or war boys, because those two go together, or could be said to go together.
Yes, because I suppose the idea would be the sum would
fairly readily say there's an overlap between CICA and what
Yes.
the damages you get out of your.
Yes. So I suppose, let me just see where I'm going to with this. And it may be, I'll come back to it when we look at MBV, that just the third general point again, and my lady, you had the point yesterday, you need to consider for what harm were the Article 3 compensation damages paid for. So, and I've got the paragraph references, but in general terms, for DSD, the harm identified was post-assault mental suffering, backed up by medical evidence. So there was psychiatric report, and it's analysed in detail in the judgment towards the end.
Sorry again, yeah, I'm getting
So
a bit
sorry.
deaf, but you're letting your voice drop.
I'm so sorry.
The harm for DSD was
Post-assault mental
Yeah.
suffering. So not there was no overlap between the criminal injury and the harm, specific harm identified for which Article 3 damages were awarded. And then for the second claimant, NBV, and that's, so I was looking, paragraph 20, it's 26 and 27 are two individual claimants, and then I've got, there's a further, for this more complicated claimant, she's the one where there was a clear causal link found between the breach, the failures in investigation, meaning that war boys had been allowed to carry on committing crimes, and she was as a result assaulted, plus post-assault psychological harm. So there was both a kind of overlap with the criminal injury. There was the injury. There was a finding of a causal link between the police's failings and the injury, and the fact of the rape, and then there was separate discrete harm. And there's, as I say, medical evidence in the bundle analysing that. So that's, so then turning to paragraph 65, which is the bit where there's a consideration of.
Well, in fact, looking at
Yes.
that again, there is specific reference actually to the liable to be repaid. So I was misremembering.
Oh, I see. Let me see.
It's the second sentence. So it was
Oh, I
specifically,
see.
it was specifically addressed and approved by the Court of Appeal and the Supreme Court.
Is that, am I being slow? We're at para 65 in Justice Green's judgment. Well, perhaps in one sense, the Court of Appeal and the Supreme Court approved it, but that was they didn't approve it subject of argument, and they thought it was right. There wasn't an appeal on this aspect. Is that right?
I haven't seen that there was, no.
Well,
I'm probably overstating. What I was really drawing attention, I've misremembered that I was thinking that the potential obligation to repay had not been specifically addressed, but it was. And so Ms. Justice Green was expressly looking at the extent to which there was overlap.
Yes. So my submission is just on this point that it's not correct to take into account the CICA award. To the extent if there's overlap in harm, there needs to be a analysis of the liability for that harm, either by the criminal perpetrator or the state body such as the police, and then CICA would be entitled to recoup to the extent it's all in respect of the same injury. What I don't.
So you say you got it wrong. Are you challenging the last sentence?
Well, the difficulty is CICA is not party to these proceedings. Yes.
You say you got it wrong.
I think so. Yes.
There are two elements. One is his conclusion in the second to last sentence that to the extent to which these payments may reflect harm which overlaps, then it's already been compensated for. So he comes to the conclusion that it is overlap, i.e. like for like. What and you say he's wrong with that too? Because I think you're saying, as I understood it, that doesn't have to be overlap. Or if I misunderstood your case?
So I think paragraph 65, there's no issue in respect of so there's CICA payments were made specifically for the consequences of the criminal assault. Accordingly, no award was made for harm. No CICA award was made for harm caused by the entirely different acts and omissions of the NPS. So that is separate harm.
Yes.
There's no recoupability. That's all agreed. To the extent which those payments may reflect harm which overlaps with the harm being compensated in this case, then to the extent it's the same harm and it's not entirely clear.
How could it be if there was no award made for it?
The overlap must be, as I understand this case, the overlap is in respect of the rape of NBV. So
what he decides, well, you can see it from the figures, and I keep getting the letters the wrong way round. But the woman, I think it's DSD, but I might have the wrong way round, who is raped first in sequence, who's raped,
yes.
and then complains to the police, and her claim isn't taken seriously. She gets a bigger convention award because the breaches by the police had a much lesser connection with the fact of the rape. She was going to be raped anyway, so her CICA award didn't really cross over with what the convention was awarding her. So she gets 13,500. But Mr. Justice Green, NBV is the more interesting one in the sense of what we're dealing with now, because he gets really stuck into what the convention award for NBV is awarding for. And here or somewhere, he says a lot of it is to do with the fact that she was raped when, if the police had done the job they ought to have done, she wouldn't have been. So the bulk of the claim in her case is for the consequence, the harm of the rape. So she's only going to get a little bit by way of convention award, but she still gets something as a convention award. He's saying there is still something above and beyond what CICA has given her that he evaluates at £2,000.
Is that
my lady, is that paragraph 144?
I'm looking at 65. That's the one I've got on my
so
screen.
those are the awards from
CICA.
Sorry, those are the awards from CICA. I'm so sorry. Yes, you're right. If you go on and look, he tells you what. I'm so sorry. Yes, that's my mistake. He gets really stuck into the weeds of what is this convention award for, and it's different in each case. And that seems to me to chime with the sort of Varnum approach. You look at the circumstances, you look at what's happened in a particular case, and your award reflects that.
So, Madam, NBV,
Sorry, it's 129 is DSD and 142 is NBV.
yes, 142, 144. So, she NBV is awarded the sum of £19,000 comprising £17,000 to include the defendant's causal responsibility for the rape. And
She
the
still
post
gets a convention award, doesn't she?
£2,000 for a portion of treatment costs. When you say convention award, I'm sorry, I'm not.
Well, as I understand it, he feeds into this. Well, the claim is against the Commissioner of Police for the Metropolis for Article 3 breaches, and he is saying, I am going to award you some money for your Article 3 breaches. I have taken account of the fact that you've had some money from CICA, but I'm still going to give you some more money for the Article 3 breaches. So they must be for something different. That's his whole philosophy. That's what he's doing, isn't it?
Or it's insufficient, or it's insufficient. But
Well, there's not a perfect overlap, I suppose, is what I'm suggesting to you. I think all I'm doing is just challenging your suggestion that, for my part, I think Mr. Justice Green's judgment is very relevant to the exercise we do, and I just am challenging the idea that he doesn't really address the point in view, because it seems to me that perhaps he does.
so therefore, that the suggestion is there is an identified separate element to the damages that aren't purely for the rape. So that, Madam, if that's right, then that's correct on this particular case. But I would still maintain that given that £17,000 includes causal responsibility for the rape, that there is an element then of the award that is in respect of the same criminal injury. I do maintain the position that actually it's giving a defendant who is liable under a convention right or other right a windfall by taking into account a CICA payment. It's the wrong way round. CICA is not addressing the court. It's not a sum that is specified as being required to be taken into account in the same way as other court payments under Section 8 of the Human Rights Act. But then there would be a separate analysis, and my lady, you may well be right, on a case-by-case basis as to what a particular award of damage is in respect of.
I'm still not quite sure whether that comes out as you saying, at one point you answered my lady's question early on, you were saying that you said Mr. Justice Green got it wrong, which you're perfectly entitled to say, it's first instance decision and we're not bound by it.
Yes.
But I want to know whether that is what you're saying, still after this helpful discussion we've had.
So he may not be wrong on the figures. My lord, I do consider it's incorrect to take into account a CICA award in a decision like this. Whether then, because as I say, yes, it gives the defendant a windfall. Is that amount to MBV lower? Does the defendant police force have to pay less than it would otherwise have to have paid if the CICA hadn't given an award? Given CICA is meant to be a scheme of last resort, CICA can assess and take a position on individual cases. I think that's my essential point.
So the real question is whether if we really do have to look carefully here at 65 and see what he said he was doing. But if what he was doing was what you've been putting to us, then he was wrong.
Yes.
The right thing would have been to give the full award against MPS. And then it was really for CICA to look at that award and see if there was any element of it which overlapped with what they had paid, and seek to get it back.
Yes.
But yes. but he should have ignored it. But you don't, so you're
Yes,
looking doubtful.
yes,
I thought
in
that is
terms
what
of
you were
the-
saying.
Yes, yes.
And in respect, sorry,
sorry.
go on, no, go on.
Well, I was just going to say, I mean, you can note the fact of the payment, but in terms of working out the precise sum to order the defendant to pay, it's not a factor to take into.
It's not what, sorry?
It's not a factor to take into account. Yes, I'm saying the same thing again, my lord.
Okay.
Yeah.
And you're coming back to overlap, is that right?
Yes, if I may. That's my last. I believe that's my last heading, unless my junior tells me otherwise. So just.
So I'm calling it overlap.
Yes.
Yeah.
So it's like for like. So I made the point yesterday, paragraph 40.
I think it would help me, sorry.
Yes, of course.
If you could start by saying, what is the proposition that you are now about to develop or to make?
The proposition is that CICA is entitled to seek to recoup the whole of its award as against any payment in respect of the same injury
That's uncontroversial, isn't it?
well, without matching, it may be uncontroversial, but I understand, I may have misunderstood the appellant's argument that CICA's, given we've got a bereavement award, paragraph 39 of 5,500, and a loss of parental services award of 22,000. Bear with me, or was that the total award? £20,000.
Sorry, yes.
Yes. My understanding of the written note is that CICA can only seek to recoup the £5,500 element of the CICA award because it can be conceptualised as non-pecuniary loss and cannot seek to recoup any element of the £20,000 because that counts as pecuniary loss. So as I understand it, and I may be wrong, the argument is that insofar as...
Well, I wonder whether it's just because it's pecuniary loss. May it not... I may have misunderstood Mr. Herman myself. It's either pecuniary loss or at any event it's a loss other than the loss for which you paid.
So
It's of a different character. You paid 5,500 for bereavement.
mm-hmm.
And he concedes that some or all of that can be recovered by you because you paid for bereavement.
Yes, he
But he says you can't have for anything else as you paid for bereavement, but you didn't pay for the losses. Just looking at my note here. Yeah, that the Article 2 award was not paid for anything other than what you paid for by way of bereavement.
So Mr. Hermer will stand up if I'm hashing things, but I think my understanding is there's one issue. Were the Human Rights Act damages in respect of the same injury?
Yes.
So looking at the scheme, you have to identify what is the injury we're all talking about. So fatal injury, death, there's a bit of, so that's the issue. That the recoupment provisions in the scheme don't say in respect of the same loss in terms of heads of loss. So the first question is, are the Human Rights Act damages under Article 2 in respect of the same injury? Are they all in respect of the injury? Are they partly in respect of the injury? Is it a mixed bag? You know, and analyse those.
Yes.
So let's say £8,000 of those. I mean, I don't know how Mr. Hermer will put it and whether that, you know, but let's assume we're dealing with a case where there was an expression of £8,000 in respect of under the Human Rights Act for bereavement, no argument that that's not anything other than consequence of the death, and an additional £2,000 for, in some sort of moral harm sense, upset for the specific breaches, whatever. So there may be an argument, well, actually, only £8,000 worth of those human rights damages are kind of vulnerable to recoupment. So then the next question is, okay, can CICA seek to take into account the whole of their award, which is £25,500, i.e. take the whole of those £8,000 away? Because, or, as I understood it, but I may have misunderstood, it is the argument that CICA can only recover at £5,500 because that's the part of the CICA
Yes.
award dealing with bereavement.
Well, okay, I think we are on the same page. And if I but it's just that your proposition didn't seem to me to get to the heart of the case that was being put against you, but you're getting there.
I'm getting there, and so so CI's position would be CICA can seek to recoup all of this, all of the award, once you've identified what the damages. If the damages are in respect of the same injury, then regardless of how CICA broke down its award, it's all capable of being taken into account in the recoupment. Firstly, because paragraph 48 doesn't require a heads of loss analysis of the CICA award. It says any payment in respect of the same injury. And it's broadly worded. You were taken yesterday by Mr. Hermer to the preceding paragraphs 45, 46, which come under the same heading, effect on awards of other payments. And if you can see that they deal in quite a lot of detail in terms of heads of award, in terms of loss of earnings or pensions, how should particular benefits be taken into account? So there's a detailed treatment in those sections, but it is a broad brush treatment in Article 48. So that supports my proposition, and that's really the main point. But a couple of follow-ups. Yes, of course.
Before you do the couple of follow-ups, sorry, I'm going back, I'm afraid to say, to DSD.
Yes.
And back to paragraph 65.
Mm-hmm.
Because Miss Justice Green decides that the CICA payments were for the consequences of the criminal assault, and no award was made for the harm caused by the entirely different acts and omissions of the Metropolitan Police Commissioner. Why were the award? why was the award made in respect of the acts and omissions of the MPS, not in respect of the same injury? Because without the rape, there would have been nothing to investigate. So they were in respect of the injury, broadly, as I understand you're submitting, interpreting that phrase as broadly as you are submitting it should be interpreted. That's not two tautologies. I mean, so why do you say he was wrong in that too? Or do you say that he was right? And if you say he was right, what's the dividing line?
So I say he was right in that respect, and that's because there is, while obviously the criminal injury was an important part of the chronology, and these acts and omissions wouldn't have occurred had the rapes not occurred, there is identifiable separate psychiatric injury, and there's medical evidence. So in terms of the analysis for DSD, it's at paragraphs 110, 11, 12, and for NBV it's paragraphs 113 to 15. There's separate harm, or if you like, injury, psychiatric injury caused by those breaches. So, and the CICA wasn't making any award in respect of those psychiatric matters. That's how I understand it. So it's
right. So it's not in respect of the same injury, even though that is the sort of cause of it all, the fact of the injury.
Well,
I'm just trying to work out how you decide whether something is or isn't in respect to the same injury on your broad analysis of what that means.
Well, I suppose there isn't the same sort of causal link. Of course, had the rape of DSD, let's stick with DSD for this example, she was raped and then there was an ineffectual police investigation afterwards. Now, it's possible in another world there would have been a perfectly adequate police investigation, so the only injury or harm would have been the rape. There wouldn't have been additional harm. So my understanding of the case is it's additional harm with a clear causal link of flowing from the failures by the police after the assault.
But that doesn't work for NBV, does it? That analysis.
Well, it works for part of her harm, yes, and then it's
Part of our harm.
there was further failures in investigations post her assault, I believe, if I just refresh my memory on the facts.
So does that mean it's the nature of the harm, or does it mean the events causing that harm, or a combination?
You just bear with me.
Sorry.
Sorry.
Because this almost seems to be going to where you said you weren't going to go. It was sort of not looking at harm, you're not looking at causation of harm, you're just looking at very generally, was it in respect to the same injury? So if the injuries are sufficiently connecting factor between the two awards, then CICA can recover. But you seem to be moving away from that and looking at harm rather than injury.
Well,
Do we?
Sorry.
I'll let you-
Sorry.
I was just to say, I don't know whether we need to look more carefully at paragraph 8 of the scheme. Which defines criminal injury, not injury by itself, though query whether that matters in this context. Criminal injury means one or more personal injuries sustained in, I said being an injury, but I suppose that means being an injury or injuries, sustained in or directly attributable to an act occurring in Great Britain. And then it goes on to say can be mental as well as physical. So in the case of War Boys, the rape is the act, the crime of violence. Injury are the injuries which, injury or injuries, both physical and mental, that the victims suffered as a result of the rape. And I can't now remember the facts, but some rapes involve significant personal physical injuries, and some the injuries are almost largely psychiatric. I can't remember the facts of DSD and MPV for the moment. I'm not sure it matters. I'm not quite sure how that advances the argument, but we must assume that the same injury is being used with that definition in para 8 in mind. Does that help the analysis?
yes, I mean, so I think it's, yes, absolutely. CICA's awards are in respect of the injury sustained during the crime of violence. So insofar as,
Well, not necessarily during, it could be some.
or as a result of.
Yes.
So, for example, paragraph 111 DSD, back to DSD, DSD suffered harm which cannot be attributed to the assault but flowed directly from the post-assault police investigation. So that's separate harm. And then NBV 113. In the liability judgment, I set out the psychiatric evidence, expert evidence in relation to NBV. This was that the police failures exacerbated the psychological harm caused by the assault, and at all time was sufficient to amount to a recognised medical condition. So my submission is that that's discrete, that's additional and not relevant to the CICA injury award, the injury in respect to which the CICA paid their compensation.
I mean, we have a complication in this case, don't we? That because we have para 48 has to be applied in the case of indirect claimants. The indirect claimants have not suffered a criminal injury. Definition of para 8.
No,
Well, perhaps they have. I don't.
I'm so sorry. There is a paragraph that I think it's paragraph 24. You may have been taken to it yesterday, page 56 of the bundle. I don't know if it was that one actually, but it's say,
scheme.
of the scheme, so sorry. So,
Paragraph 24.
yes.
I mean, if you look at 39,
Mm.
sorry, this isn't helpful to the analysis of DSD and
No.
MBV, so perhaps I ought to postpone it till we finish dealing with DSD.
Well,
But perhaps you said all you
I
wanted to
think
say.
I've said all I feel I'd like to say, unless you have anything else arising on that. I was addressing you in terms of the like-for-like issue, but I mean,
I know you were, and I wasn't trying to get off that. We got to see what the wording of 48 implies about whether or not you take a like-for-like approach or a double recovery approach, which, in case of which, is double recovery for the same thing. Otherwise, it's not double.
yes.
And I'm just there's a complexity about the language of 48, because 48 is really more apt to the case of a direct victim. Para 39, which gives the rights to the indirect victim, doesn't say that the indirect victim has suffered an injury. It simply says that in consequence of the injury to the direct victim, they have these they are entitled to these further awards. Now, again, I'm not quite sure how that assists the analysis, but one has, when looking at the language of 48, to bear in mind that we're applying it in this kind of case, in a case which has this extra complication. Because we're talking about different heads of loss for a secondary victim who hasn't suffered an injury at all. So how does analysing the phrase in respect to the same injury really help? You've got to work it out from first principles, haven't you? Given the underlying policy of the Act, which we know is to prevent double recovery. See the
Well, my lord, I think my response to that is that the paragraph 24 and elsewhere makes clear the injury, the identification of the injury is the same exercise whether you've got a living direct victim of the crime or that person has died. The second point is the recoupment provision.
Let me just look again.
24 is slightly oddly worded because it's saying, for these purposes, where the victim has died, any application made by the victim before his or her death, and any application made by a qualifying claimant after the death would be regarded as being in respect to the same injury. And if you read that literally, it might suggest that you set one off against the other, which I think would be odd.
I read that as
Will each be regarded as what in? Do you see what I mean? Because the award to the victim in respect to the application made before the death, and the award made. Is that being too over analytical?
I know we have to grapple with the wording of the scheme. When one makes an application to CICA, there's a form you fill in and you identify the injury and you identify your standing as a claimant.
All I'm referring to is the fact that in this paragraph as well, we have the phrase "in respect to the same injury."
So,
You see what I mean?
yeah.
And there are claims being made by different people.
my lord, yes, I my reading of that was that it was helpful clarification that applications are regarded as being in respect of the same injury. So I'm not aware that in this case, there can't have been in this case a preceding application.
No, I understand that.
So,
it might simply be that it shows that you've got to treat the phrase in respect to the same injury with some caution.
And across 24 only says it's for these purposes. It doesn't say for the purposes of section 39 or section 48 rather.
So to be entitled to any compensation under this scheme, you have to be a qualifying claimant, whether direct or indirect. You identify the injury, and just sticking with the paragraph 39 bereavement award under the CICA scheme, the obvious example would be, say there was just keeping things really simple, a claim against the criminal perpetrator who murdered the relative, and you're seeking a bereavement award under the Fatal Accidents Act, then that would be a payment of compensation or damages under paragraph 48 in respect of the same injury. So you've got your compensation from the criminal perpetrator, and therefore CICA can recoup their tariff award.
Okay. I see the time, and we've slowed you down a good deal. We must leave some time for Mr. Hermer. We may sit, take a slightly late lunch in order to finish. But how much more have you got to say?
I've got 5 minutes, so I've just got.
We'll let you do your 5 minutes, and try not to ask any questions unless we feel we have to.
Well, yes. So I was addressing on like-for-like recovery. I'd given you my first point about the wording of paragraph 48. The second point is, so to the extent it's suggested that only, say, a bereavement award can be offset, a tariff award under the scheme can be recouped against a bereavement award, or a loss of earnings claim can only be recouped against loss of earnings claim, or pecuniary versus non-pecuniary. Only non-pecuniary damages can be recouped against non-pecuniary, etc. This sort of like for like. My submission is the scheme has to be workable. Settlements are often on a global basis without identifying separate figures for heads of loss. Defendants might make here's £200,000, off you go. And that, by the way, that includes costs or whatever. So, and there may not be exactly correlating heads of loss. So it would be putting an administrative burden on CICA to kind of draw. It's putting a further administrative burden on CICA, and you may feel that that's part of the rationale for paragraph 48 being worded broadly as it is. And just on, I suppose it's my third point is a development of the second. If I've understood correctly, the appellant's argument is objecting to recovering for CICA taking into account the loss of parental services award from under paragraph 42 of the scheme, because because it can be categorised as a pecuniary loss, whereas the Article 2 damages were non-pecuniary. So my answer to that is, what's the logic in drawing that line between pecuniary versus non-pecuniary? Why not say, as a matter of principle, as I was saying, each head of loss needs to be matched against each other in order to recoup without offending against a double recovery concept. The same points arising in terms of workability, administrative burden. CICA scheme applies across the UK, including Scotland. So you've got different, well, for example, the Fatal Accidents Act doesn't apply. And it may be there's a danger of artificial ring fencing of settlement awards. So again, further arguments as to why my respectful submission kind of like for like head of loss analysis is not correct, and that's why the wording of paragraph 48 is in respect of the same injury rather than in respect of the same loss slash, damage. So I think those were my submissions, my lord, if I might just double check. Thank you. Thank you.
Well, Mr. Hermer, I know you're very succinct. We will be impressed and grateful if you can finish in 12 minutes. We may allow you to go a bit further if you need to.
Thank you, my lord. Can I deal with the last point first? My learned friend accepts that paragraph 49 seeks to give an effect to a double recovery rule, but yet she says it doesn't involve a like-for-like analysis. For a start, anything that departs from a like-and-like analysis departs from the enforcement of the double recoverability power or rule.
Well, maybe doesn't that assume what you have to prove? Double recoverability of what? Double recoverability of damages for the same injury, or double recovery for the same heads of loss? That's really the question.
Well, my lord, it has to descend in this context to the granular level, because otherwise we depart from any other known concept of double recoverability, whether of the type that Mr. Justice Green sought to avoid in the human rights context in DSD or in a general common law context. Double recoverability is a well-known concept. You don't get paid for the same injury or the same loss twice. Because otherwise, were it not that, you are reading in a power to take money, to recover monies that you in fact did not give out. And that must be wrong, and you certainly can't interpret it in our respectful submission by notions of workability or administrative convenience. That's not at all of interpretation. You can test an interpretation by would it lead to manifestly perverse outcomes that could never have been intended. But it's not a tool of interpretation to say it's difficult to administer. And indeed, it's not difficult to administer. The authority is perfectly able, as it no doubt does, to ask for details of the basis of a settlement.
Well, that's a meaningless question, isn't it? They say, I don't really know. The two parties may have different ideas as to what they agree the right sum is 10,000, but the claimant might think, I want 10,000 because of 8,000 for element A and 2,000 for element B. The defendant might say the other way around, but it doesn't matter because it's only money at the end of the day and it's 10,000. Well, there may not be consensus.
There may not be consensus, and it may be the authority needs to take a view. But that is not this case. On this case, there's been absolute clarity as to the components of the settlement award, what was originally claimed, what was given up for the purposes of a settlement. The settlement here corresponds exactly to what was sought by way of non-pecuniary losses for Article 2. Doubtless the CICA can ask, could we see the schedules of loss or your letter of claim, so we can correlate with what you've settled to what you claimed. In cases in which that might be just impossible, They can make their assessments, and if the claimant feels that that's an unjust one, it can be challenged
On what basis?
on the basis, well, it may be very difficult for a claimant who's not able to demonstrate how their award, their settlement was made up, doesn't fall within the CICA award. They may or may not have materials to show that. But it's not this case, and nor should it be assumed it's going to be many cases.
Sorry, can you just help me? What is the right of challenge? Is it in the Act or in the? Is it a public law challenge or
It's
is
a public law challenge to the First-Tier Tribunal.
It is.
I think
Okay.
it's a step, yeah.
And it's provided for in the Act, is it? Or is it? No, it's just general law.
I think it's a general law challenge to the First-Tier
Right.
Tribunal. but
So it'd be
I
a
don't-
rationality. There's no rational basis for the
I'm sorry, I'm
CICA coming to the conclusion it came to about the.
going to give my lord an accurate answer.
Right.
It's a right of appeal to the First-Tier Tribunal with the right of judicial review.
Excuse me.
It's a right of appeal to the First-Tier Tribunal, and then a judicial review to the Upper Tribunal.
Okay.
Is even that right? I see. So it's a judicial review to the Upper Tribunal, not a right of appeal on point of law only. It doesn't really matter, it becomes the same thing, but that, I see.
And the right of appeal just is in the Act or is somewhere else? Or is it in the Tribunal?
I'm so sorry, I should have a ready answer to my
No,
lord's
don't
question, and I don't, and I don't want to give you an
But
answer on that.
your junior does,
But
maybe he doesn't.
we'll provide it to the court.
You're just dealing with that, the workability, with the perverse outcomes.
Of course.
If you can see the grounds on which.
One way or another, it's clearly, so it's judicial review type ground.
It's just
public
review,
law.
and here it would be clear what the ground is, which is that they failed to interpret paragraph 49 correctly. Got it wrong in law.
Well, no, in a case where it's not clear on what the components of the settlement are,
Oh, I'm so sorry, my lord.
and I was saying, you were saying, oh, well, you can always look, and I was saying you may look and it may not tell you. It may just say lump sum.
Yeah.
And you were then saying, oh, well, in that case, they'd have to make an assessment. They'd have to decide how much was attributable to this and how much was attributable to that. You just assumed that would be something they could do and it could be challenged, but it could only be challenged on the basis it was irrational. But I'm just wondering what the nature of the exercise would be when you were assessing. I think this £10,000 was £5,000 for this head, which we paid for, and £5,000 for a different head, which isn't covered. I don't know how you'd set about doing that. You'd simply be saying, well, if I was the parties, this is how I would have done it.
Well, no, or you ask the parties.
Yeah, but
You assess the nature of the response and the quality of the
but you
evidence.
asked
on the
both
response.
parties.
I'm so sorry. I thought my lord was asking me if you're a CICA caseworker, what does one do in that basis? But
Yes.
my lord,
You say you'd ask the parties. If the question is what was this payment for, that's a question which it doesn't seem to be obvious that the claimant should give you the answer. You can say, I arrived at it in this way. But I've no idea how the defendants arrived at it, and in fact we know the defendant said that's not right at all, but it doesn't really matter because it all comes out of the same in the end. So we're paying on one basis, you're paying on the other, but it's the same sum of money. So you're saying is it what the claimant thought it was for that is determinative, and that in theory at least you could ask for. Am I muddling you, or are you muddling? Am I being muddle-headed? In which case, don't be embarrassed to say so. Don't be embarrassed to say so.
well,
Use other words if you prefer.
my lord, can I park that for this reason? Is it doesn't, in my respectful submission, ultimately help you with the interpretation of the meaning and effect of paragraph 49. My main point on that is if it's accepted that this is giving a power to give effect to a double recovery principle, that you can't accept that on the one hand and then say, but it nevertheless also gives us a power to deduct other than on a like-for-like basis. And you certainly can't do that, and you certainly can't advance that interpretation by reference to notions of administrative convenience.
Okay.
And this case is an example, and I accept there may be other cases and at the other end of the scale, but this is a case in which it can be readily seen that applying the broad approach of contended for by the authority would in reality lead to double recovery, contrary to the purpose and meaning of Article 49 properly construed. Now,
Sorry,
as a-
just go with that again. Is there a-
this case is an example of how this broad power contended for by the authority would lead to
Something more than double recovery.
Yes, I think you're saying the
because
opposite.
it's more than double
Yes.
It's
recovery.
not merely double. You wouldn't have a
Yes.
point if it was
Yes.
merely double recovery. That you'd say that was fine.
What you mean is they're taking away more than they're entitled to on the basis of double recovery.
Yes, because
Yes, okay.
because the authority seeks to say, well, double recovery must be taken to mean something other than ensuring there's only deductions on a like-for-like basis. And my submission is, well,
Well,
that's
you see,
inconsistent with double
what I'm
recovery.
just puzzling about, and when I think about it more, it may all go away, is this like-for-like basis seems very obvious. But actually, doesn't it beg the question, as you say, of how granular you have to be? If you're dividing it down into heads of damage, and then you take away more than was paid for that head of damage, but it's all part of the injury for the same case, is that really is that taking away more than you're entitled to?
It absolutely is, and would be exemplified by the facts of this case. So I'm going to come on to in respect of injury separately in a moment, but it absolutely would on the facts of this case. So there's no attempt by the authority, for example, to say that loss of services of a parent forms any part of an Article 2 non-pecuniary award. But yet they say they're entitled to take thousands of pounds from that award in respect of it, because it's simply in respect, broadly speaking, in respect of the same injury. There's
Take an Article 2 award. Why couldn't it be part of an Article 2 award that you've lost the services of your parent to help you with your?
You could add a claim for non-pecuniary losses on your Article 2 claim for that very purpose.
Yes.
And you'll see from the claim letter that not under the.
Well, they didn't do it. You're right. They didn't do it in that way.
They didn't do it in that way. So
But
it doesn't.
are they bound by the way in which they did it? If it's ultimately an Article 2 loss, a loss for which they would receive recovery.
Well, it's certainly not part of a non-pecuniary Article 2 loss.
Okay.
There's no suggestion that it is. But yet, the authorities say, without offending the principle of double recovery, we're entitled to take that money, even though there's no analogue. And that's double recovery.
That's more than double recovery.
It's more than double
It's
recovery.
not-
I'm so
it's-
sorry.
Yes.
It's more than you're entitled
Yes.
to.
Yes. Okay.
It's going beyond the
It's
power
more
that's
than
been granted
recruitment.
to the authority.
Yeah. Now, I see very much what your case is. I'm just testing it against this point, which really came up at just the last closing parts of his web submission. All that appreciate it's there in her skeleton. Effectively, you shouldn't have to divide up the heads of damage so granularly, but you're saying you should, and for the reasons you've given.
Yes.
Okay. Well, unless you want to say more, I see where the argument lies.
Well, look, can I then just deal with this question, which is related, which is there an opportunity within the meaning of the paragraph for the authority to have this kind of broader definition allowing them to take any damages as long as in respect of the same injury? And they base that analysis, it appears, on a common test of causation, or at least a test in causation under Article 2 that ties the case to death. And they say an indirect Article 2 case is a case in respect of death. The award under the scheme is in respect of the death. Therefore, they are in respect of the same injury. Now, the courts had my submissions as to the very distinct jurisprudential difference between what a indirect Article 2 claim for a breach of a positive duty is directed at, and what the purpose and scope of society compensating for criminal acts of third parties. So they are so distinct. But insofar as the authority seeks to say, you classify through a common test in causation, I mean, as a matter of principle, that's not the way that you would seek to classify claims, just simply because they share a test in causation. But in any event, as I've shown you already, for the purposes of a breach of Article 2, it is not necessary to prove, not only is it not necessary to prove on the balance of probabilities a link between breach and death, for the purposes of establishing liability, there is no real causation test. And can I just show you a recent decision of this court to that effect? Which is a decision in Saran Janssen, which the court will find behind tab 16.
Sargentson, yeah.
And this was a case, it's an Article 2 case, but in which the applicant didn't actually die. He was just very seriously injured. Because, of course, you don't need a death, per se, to engage Article 2. And could I just direct you, please, to paragraphs 28 to 29, where in the judgment of Lord Dyson, with whom the other members of the court agreed, the test of causation is addressed. So it's 28 to 29.
Wow. Well, it strikes me as counterintuitive, I must say, but
Well, my lord, I think the history of the introduction of the convention directly into law under the Human Rights Act are several moments of counterintuitiveness. I mean, we've seen that already with developing understanding of whether or not there's a right to indirect victims. House of Lords originally said no, subsequently said yes. But in any event, my lord, I've shown you Lord Brown in Van Colle, paragraph 138, which refers to...
well, perhaps it's not so wow. I assume that what Lord Dyson was meaning in paragraph 29, and so if it were established, it could only mean established on the balance of probabilities that a timeless response would have made no difference. That's perfectly consistent. There was still and that's all it could ever have been. If it were established that it could in no circumstances, there was no chance of it making any difference at all, then I would find that very surprising. But I don't think that's what he meant.
And my lord, it's not necessary for my submissions, because my submissions on this particular point amount to this. You cannot categorise the indirect victim's claim for a breach of the positive obligations ante-mortem as a claim in respect of the same injury as the CICA.
No, but
on
the point
basis
here
of a
is that an
causal-
injury has happened, and the scheme is tied to the injury, and the damages that were paid for the injury.
Well, the breach in an indirect. So
They were not paid for the breach. They were paid for the damage, paid for the injury which resulted from the breach.
Well, only to an extent, and that's one of the issues before the court. Are they all in respect? Of
Well, that's a separate point. But just suppose that moral damages actually only means pain and suffering. I know you say it doesn't mean that, but suppose that's what it means, and there would have been nothing if there hadn't been a death, which actually slightly what is being suggested there in Sargentson. Then, although of course in one sense you're paying damages for the breach, you're actually paying damages for the injury caused by the breach. And that's not true under Article 2, just as much as it's true under for the compensation award.
Yes, I mean, to an extent. I mean, the court could, my submission, still beyond. Well, it depends on, I suppose, where one gets to on what moral damages mean. But certainly, in respect of the egregiousness of the breaches, ante-mortem breaches, that could still form part of a compensation component.
Well, I wonder whether it could if the ante-mortem breaches had caused, which they probably wouldn't. Post-mortem breaches often cause psychological damage. Or post-injury damages sometimes do, like as in the rape cases. In theory, the breaches could cause psychological injury, even though there wasn't a death, or there was a death. Someone knew that the person was stalking outside for weeks and was very upset, and then was killed. In that case, you'd have a different injury. But there's no different injury here, is there?
Well, I think my
The
Lord,
only injury is the death.
well, I'd seek to draw a distinction for the purposes of a human rights claim for a breach of convention as to what the injury, what the heart of the breach is. Injury is the breach in a convention case of this nature,
Well, is it?
for which you are entitled to damages, some of which may or may not cross over with the CICA or with common law.
Well, we'll have to look at the cases again. I don't regard it as self-evident that where you pay Article 2 damages, it makes sense to say you're paying it for the. In one sense, obviously, there has to be a breach, because otherwise we haven't got, in English terms, a cause of action.
Yes.
But what the damages are for are the suffering you've suffered for that breach, which may be psychological, may be actual, may be direct, may be indirect. But there's always got to be an injury.
Well, an injury,
Unless you're right about moral damages.
yes, an injury means something within convention law that has components of it that are quite distinct in my submission.
Well, it may
from
come
any
back
other aspect
to that.
And in support of that, of course, I rely on the list of authorities I took you to, from you were taken to Greenfield, to Van Colle, and not least this court and the Supreme Court in DSD.
Yeah.
This is a rights-based framework. It's not a tort statute. It addresses the breaches of the rights. And of course, the court will draw a clear distinction between maybe a direct Article 2 case where you've got a state agent who kills the individual, which is addressed at the actions of the state agent. You can see a clear analogue with a CICA award being in respect to the same injury there. But something that looks at different aspects from an indirect victim, different aspects of the human rights framework, which is about the preventative measures that the state has to give effect to. And the purpose of the claim is to vindicate those rights. You may have a right to damages
But
from
you
it.
do that by getting a declaration of a breach. So it does come back to the question of what the damages are for.
Yes.
And that's
Well, that I'm going to turn
quite
to.
nubbly. You're about to take us to that, and including to the presidential statement, the practice direction. Because the practice direction looks quite English.
Yes, I mean both
May well have been.
both in form and content. Firstly, my respectful submission, a summary of general principles in a practice note cannot be a shortcut to analysis as to both what the Strasbourg case has said and our own courts have said.
It certainly can't be determinative.
It
but
can't
it's
be determinative.
The President presumably knows quite a lot about how the court thinks and is able to read the judgments with a Strasbourg eye. And that's how I suspect it was Miss Justice Bratzer with the original version and someone else since. But
well, we've seen the rule that
Yep.
doesn't actually
No.
provide a power to clarify law, let alone declare.
No, I was rather
law.
surprised that
On any view, it might be a helpful guide to practitioners as to how they approach cases, but there's nothing, certainly that I'm aware of, in Strasbourg jurisprudence in which the court has developed the law with regard to a practice direction.
No. Okay.
And nor in my respectful submission should this court. can I finish my submissions with just 3 very short additional points?
Of course.
Because the court, if the court accepts that paragraph 49 has to be read to provide a power to police double recovery, no more, no less, then it is obviously the most central questions are the degree to which there has been double recovery in this case. And that requires both an analysis of the CICA's award and the settlement award. And as to CICA's award, and the extent to which there is a crossover, which in this case is broadly focused on the question of grief of the applicant. On CICA's own analysis, their 5,500 does not comprise entirely of grief. It also includes the fact of death itself. Those are my learned friend submissions, and she also draws your attention in her paper this morning to the command paper, talking about giving a sum for death. And so there is a component in that.
Bit of a shorthand, isn't it? I mean, and if I may say so, it's you who's talked about grief.
Yes.
When a loved one dies, you can use all sorts of words. There may be grief in the sense that we all understand people are miserable. There's also, in a more general sense, a sense of loss. And the general heading bereavement is probably not a bad general way of describing what I would have thought the common law and therefore it's not strictly speaking a common law because it didn't exist a common law, but Section 1A and now and CICA are all trying to pay for, so trying to compensate for. So to draw a distinction between grief and something other than grief, which you call loss, is I find it difficult to get my head around.
I'm not doing that.
Okay.
I'm not seeking to draw a distinction between the impact of the death, different types of impact on the death upon an applicant, whether you know the distinction between grief and loss. The distinction I'm seeking to draw is the components of the 5,500 that seek to compensate the applicant themselves for their grief or response to the death, the bereavement, and an aspect of the award that stands as symbolic of the fact of death of the deceased. And my submission is, and I hope consistent with the way it was put by my learned friends and consistent with the command paper, is there is at least an element of the 5,500 that stands as recognition of the fact of death. Not the consequences of it, but the fact marking the fact that the life has been wrongly taken and reflecting that. And that would be a entirely consistent jurisprudential approach for non-pecuniary loss to mark the fact that something has occurred in that sense. And so my submission is you cannot proceed on the basis that all the 5,500 would find a analogue in the Human Rights Act settlement, which of course itself, for an indirect victim, the fact of death plays no part in an award. It would do if it was a direct victim, but not for an indirect victim of a breach of a preventative obligation. So that's all I wish to say about the CICA award, which is don't assume it's all of the 5,500, except my second ancillary point is it can't include the loss of services of a parent, because that has no analogue. It's a pecuniary loss, as would be analysed in common law, and we provided you with the judgment of Mr. Martin Chamberlain as he was sitting as a deputy in that case.
What's that called? Do you remember?
It's back of it's tab 34.
It's the new grant.
It's the new one grant. Yes.
Yes.
And there's a helpful
Well, perhaps
analysis.
I know you're quite rightly trying to be succinct. I think I wouldn't mind just seeing the paragraph.
Of course.
To which you.
Can I just reel back? I think I might have written the note. You're saying the CICA award can't include loss of services of parent, and that's not right. The CICA award
No.
doesn't include loss of services of parent. It's your convention.
It's the convention award has so to some degree, whether or not you classify that part of the award as pecuniary or non-pecuniary, you say it's clearly pecuniary, it doesn't matter.
Doesn't matter.
What matters is, does it have an analogue? Is there a crossover? If you're applying the principle of double recovery or avoiding more than double recovery, that's the relevant question. And it's only the question as to whether it's pecuniary or not that's addressed in the case of Grant.
Yes, I see. So it may not actually be at the heart of the argument, but
It doesn't matter. It's just
Yeah,
that
so
it doesn't matter really what you call it, is it? It's what it's for. We need to get inside, isn't it, and work out.
My lady, entirely agree. The determining factor in this case is there's no suggestion that the loss that's being compensated for by way of an award for loss of services as a parent forms any part of a non-pecuniary award for an indirect victim of a breach of Article 2. And so an attempt to recover it would be going way beyond powers to avoid double recovery. That's the simple point I make.
I had para 94 of Grant flagged. Is that the right one?
Yes, the discussion is from 94 through to, really through to the end of the judgment, and His Lordship sets out how this head of loss has developed and why it must be in common law a pecuniary loss, because the only form of non-pecuniary loss arising after a fatal accident is the statutory award. Anything else is
yeah,
pecuniary.
no, I see some force in that.
But as my lady says, ultimately it doesn't matter here. Ultimately, the material question
It's
is
pecuniary. It's pecuniary in character, even though it may result in general damages
In the lump sum.
in a lump sum. Yes, rather than
Yes,
special.
exactly.
Yes.
exactly.
Okay.
Finally, can I say this in respect of damages under the Human Rights Act? I've accepted throughout that it certainly would contain an element that reflects the grief and the distress and the impact. I couldn't submit otherwise on the basis of Strasbourg and domestic authorities. But it would be a mistake, in my respectful submission, to analyse the approach of Strasbourg to the quantification of an award through the prism of a tort case. And the court has been materially assisted, in my respectful submission, by the analysis of Mr. Justice Leggett in Al-Saran, identifying the various components of an award that include the conduct of the defendant, with no suggestion that it's the impact on the applicant of the conduct of the defendant that is the determining factor. And can I give you two other references? I think you've been taken already you've been taken by both of us to Rabone, but you can see some of the factors, some additional insight at paragraph 85, page 440. In which Lord Dyson, by reference to Savage, in the first instance decision in Savage, talks of the factors that one would have regard to in an award. And if we could just pick it up by G.
Oh, sorry, I hadn't let you go on there.
Para
I'm so
85.
sorry.
Right, remind me.
Page 440.
Yeah.
If one picks it up by just above G, as the factors one would expect the court to have regard to, obviously the closeness of the family link, but also the nature of the breach. So there are factors here that are plainly claimant specific, but there are also generic, including the fact that the breach is especially egregious.
Yes, those are all explicable. I would say they're all rationally explicable on the fact that the nature of the breach and the egregiousness of the conduct may feed into the impact on the individual.
Well, my lord, the difficulty with that is that, in my respectful submission, falls into the trap of looking at it through a tort paradigm.
We
Rather
don't have to be
than,
ashamed of tort. It's not.
no, but it's not the essential tool, my lord, for interpreting and understanding how damages would be awarded under a convention in the context of the cases which I showed you, of the purpose of just satisfaction awards under the convention being upholding rights. So it's unsurprising in those circumstances that at least a component of those awards will
Yeah,
be
I
for
see
the
how you
fact
put
of the breach of fundamental rights in itself, because that's the purpose of the convention. And to make it effective, people need to be able to bring cases to court. And that's why the conduct of the defendant and the egregiousness of the breach may well be relevant factors. It may not matter in this case because I do not contend that a modest deduction from the authority would be would overstep the mark in respect of grief, the grief element of the Article 2 award.
Just say not the whole amount.
Just not the whole amount. Because I don't contend that the grief element, the
Well, I think-
impact is insignificant in an Article 2
Now,
award.
I understand that, and we're going to going over old ground.
Yeah. My lord, unless there are any further questions from the court, those are my
From
submissions.
me, my lord and my
I thought
lady.
you said there were going to be 3 cases we were just to look at. Alceran, Raybone.
Oh, I'm so sorry. I was going to give you also, I'm so sorry, paragraph 138 in DSD, in which Mr. Justice Green took account of factors that on the face of it appear to extend beyond the impact on the victim, but looked at the nature of the defendant. It was just an example of the principle identified in Rabone. I'm so sorry. I hope that's helpful.
Thank you. Ms. Webb, you're entitled to come back on new authority. That's really only Grant, which I don't think really.
Sargentson.
Sorry, I was about to say, so Randy Grant, about which I think you've said all you need to say, unless you want to say more, and Sargentson, as Melody reminds me.
So, my lord, just briefly on Grant, it's just to be a little pedantic. The issue and discussion of damages was not strictly speaking under the common law, but rather on the Fatal Accidents Act, which is very strict in terms.
That is very pedantic, but
Yes,
I like accuracy, so don't mind.
So I just thought I would flag that because obviously general damages are not available in the same way as in a standard court tort claim. On Sargentson, my lord, I would have simply made the point that you made on the test, on reading that case, which isn't very clearly written, that the test of causation must have been referring to a but-for rather than the lesser test under
Yes.
the convention, and a careful reading of paragraph 28, which I think exerts Kilic and Turkey or such, does flag a link between the breaches at the time and having had a potential material impact on risk or what have you. So I think that's all I'd have to say. Thank you.
Thank you. Well, obviously, we will be reserving our judgments. Before I go to the usual rigmarole about that, which you're very familiar with, I want to say a genuine thank you to both of you and those behind you for the amount of work and thought that's gone into this appeal. And also to say the court is very aware that although we've had to be concerned with highly arcane legal points, and the sums of money may seem small, this has wider implications, and also that it reflects obviously a real human tragedy, which we are very alive to, and the fact that we haven't constantly referred to doesn't mean we're unaware of.
Thank you very much, Madam.
Well, I think at 1:25 I'm not going to give you the normal form of words about the effects of a reserve judgment. The only key thing is remember the Counsel General for Wales case, but the rest I think you all know. Right. Thank you very much. much.
Thank you, Mike.
Thank you very much.
Thank you.
Thank you.
Don't tweet the results before it's been handed down.
Yeah. So, okay, just check.